Hello, let's take a look at this multiple choice question. Victor is talking to Ben in Ben's office when they have a heated conversation. Victor walks out, slamming the door behind him. Because of a flaw in the lock, the door locks from the outside, keeping Ben inside the office. Upon noticing that he can't get out, Ben calmly tries to jiggle the lock before calling his wife. The question: can Ben successfully sue Victor in tort? Okay, the first thing to consider would be what tort can Ben sue Victor for? And we will, after reviewing all the torts, the one that makes most sense is false imprisonment, which we will examine presently. Okay, and the elements of false imprisonment are shown here. So the defendant, in this case Victor, should have committed an act to confine the plaintiff, Ben. The defendant, Victor, here needs to have intent to confine. And the action that Victor performed should be the cause in fact of the confinement and should be the legal proximate cause of confinement. And notice here that the plaintiff needs to have been aware of the confinement, although the exceptions are that a child or an incompetent person does not need to be aware of the confinement. A summary definition is here at the bottom, but basically the summary definition just points at the graph and the necessary elements of false imprisonment. And on the side here we can see that a valid defense for false imprisonment would be consent. That is, if the confined person previously gave valid consent for the confinement. So we have these important elements. We need to check whether Ben was aware of the confinement. The fact pattern tells us that he was aware, that he noticed that he could not open the door. That's enough for awareness. We notice that the defendant, Victor, did perform an act that did confine Ben. That is, he closed the door, slammed the door, and caused the lock to lock in such a way that Ben could not open the door. Now the big question here is intent. Did Victor have the intent to confine? And here we'd have to find that Victor did not have the intent to confine. Victor only had the intent to close the door. Even if he was slamming the door, usually we do not get the result that a slammed door locks from the outside. So I don't think we're going to be able to find that Victor had the intent to confine. And for that reason, false imprisonment will not hold here. So if we look again at the question, we can look at the options and say, can Ben successfully sue Victor in tort? No, because Ben was on his own premises. Well, being on one's own premises is not one of the necessary elements of false imprisonment. As we saw in the graphical summary, if it doesn't exist as a necessary element in the graphical summary, then it is not a necessary element of the tort. A is incorrect. Option B says no, if Victor did not intend to lock the door. Well, Victor, in fact, did not intend to lock the door. He only intended to slam the door. So B looks like a correct answer. C looks at negligence in slamming the door, and we will take a moment, just a second, to examine negligence. And D says, yes, Victor can be found guilty of false imprisonment because he caused Ben to be confined. Well, this is only looks at one of the necessary elements of false imprisonment, which is to be the cause and fact of actual confinement, but this is not enough to secure the being guilty of the tort. It's just one of the necessary elements. The key element here, the one that's going to prevent Victor from being found guilty of false imprisonment, is the fact that Victor did not have an intent to lock the door. Let's take a moment to look at negligence and see why negligence is not very probable way of proving any liability in this case. Okay, so let's take a look at negligence and see why it is such a tenuous tort to prove in this case, and also tenuous to prove in many cases. Negligence requires the breach of the duty of care by the defendant, and it needs to be shown that the defendant breached his duty of care by the acts that he performed and caused damages to the plaintiff. So the first difficulty that we have here is that the defendant, Victor, we can question what his duty of care was in an office situation and in a heated conversation situation. And it can be argued back and forth whether someone who's in a heated conversation or even in a calm conversation in an office setting, what duty of care they have with regard to how brusquely they close or open doors. That's a very tenuous case in itself. The second major area is causation, and here it would have to be proved that the slamming of the door in fact caused the lock to close from the outside. Well, that can be debated because there seemed to have been a flaw in the lock which caused the door to lock unexpectedly. And thirdly, the third major area is damages. The plaintiff needs to show damages, special damages, that is specific damages to his person, and also perhaps pain and suffering. So those are not present in this situation, and so negligence cannot be proved against Victor. And you can see here, because of all the necessary elements that need to be proved for the tort of negligence, that negligence is often a tenuous tort to prove. You also have some very significant defenses to negligence. For example, comparative negligence by the plaintiff. Perhaps here the comparative negligence was causing an argument to ensue and other acts to ensue from the argumentation. And in other cases, the assumption of risk is a defense to negligence. So negligence is not easy to prove. It's better to go with the intentional tort of false imprisonment.